And we want to look at this, how this relates to the United Nations Conventions on the Rights of the Child. So the UN Convention on the Rights of the Child, as Marit mentioned, is the most widely ratified human rights treaty in the world. It's ratified by almost all UN countries, apart from the United States. It's also the most comprehensive convention on human rights because it includes social, cultural, economic, and civil rights, which no other human rights convention does. So really, the UN Convention on the Rights of the Child is what sets the global standards for what children's rights should be. And if we make decisions that concern children, professional decisions and judgments, we really need to consider the rights of the child. That is a legal obligation. But the question that we want to ask is whether, the UN Convention on the Rights of the Child also has four guiding principles. And one of these principles is the right to participation, or the right to be heard. And that those principles are guiding how we interpret the convention. And really, the right to participation and the right to be heard is really where in decision-making we really see an impact of the Convention on the Rights of the Child today. And then the question is whether these standards are relevant. Are they relevant for jurisdictions across the world, or are other bigger concerns what really takes up most of the time and most of the attention? Should the United Nations Convention on the Rights lead to different ways of working professionally on the ground? And how could the UN Convention on the Rights of the Child assist states and be an instrument that shapes decision-making and courts in becoming professional and in line with the Convention? So with us today we have two legal scholars and two political scientists that will each present and give their perspective. We have three speakers who will speak for 10 minutes each, and then we'll have comments from the fourth commentator. So I'd like to welcome the panel today. We have Anne Mette Magnussen, who's a professor at the Western University School of Applied Sciences. Carl Harald Søvik, and she's a political scientist. Carl Harald Søvik is a legal scholar. He's a professor of law and dean of the law faculty here at the University of Bergen. We have Helen Stalford, who's a professor of law at the University of Liverpool, and we have Oskar Falk Eriksen, who's a political scientist at Oslo Metropolitan University. So welcome. I think you can take your seats, and we'll start with you, Anne Mette, who can present your presentation. Thank you. Okay.
Thank you, Amy. I will use this opportunity to make some reflection on law, rights, and professional practice. As stated in the introduction to this panel, the UN guidelines on involvement of children in decision-making is a legal instrument, is a legal document with global reach and thus a cosmopolitan imprint, as well as the most far-reaching document explicitly stating the rights of children. The guidelines suggests 9 conditions that are necessary to fulfill participation for children. They should be transparent and informative, voluntary, respectful, relevant, inclusive, supported by training, safe and sensitive to risk, accountable, and child-friendly. I would like to use or take this opportunity to make some reflection around the possibility and the limitation in governing professional discretion through these kind of general principles and standards. Before I continue, I must say that I do not have much research experience in the child protection field, but I will draw on some of the research that we've conducted in the health field, which I think also is of relevance for child protection. First of all, standards and principles are important. They concern the values, norms, and principles the question of children's participation should be based on. The introduction of children's right to participation is an important tool to make the relevant decision makers in accordance with superior values. The idea that it's possible to govern professional decision making by such detailed guidelines is, however, a very ambitious project. The introduction of children's rights of participation may also reflect an optimism regarding the capacity to regulate professional decision-making. There are some reasons to question this kind of optimism. First of all, there are several factors that influence the impacts of rules and individual rights. Here I can mention how clear, consistent, stable, and uncontroversial signals the rules or rights send. How the rules or rights are interpreted by the decision makers. To what extent the rule or the right is perceived as reasonable, fair, or natural by those who apply them. Or whether the decision makers are motivated to follow the rules. And to what extent do they feel that resources are sufficient to comply with the content of the rule or right. Despite the overall goal is to secure children's participation, the 9 conditions introduced needs to be interpreted by those who are supposed to adhere to them. For instance, what it means to be informative, respectful, relevant, inclusive, can be answered in different ways, in different situations, and in different contexts. Let me use an example from the health sector, and more specifically from the question of prioritization of healthcare, to illustrate this argument. Prioritization means to set something before something else. In healthcare, prioritization has to do with the way some individuals, populations, diseases, or services are allocated more resources than others in terms of treatment, quality of service, or research attention. It also concerns the question of how long patients have to wait before investigation or treatment is effected. Over the last decade, the Norwegian healthcare system have developed strong legalistic characteristics. Prioritization of healthcare service is mainly regulated by the Patients and Users Rights Act. This stipulates the rights of patients to receive necessary healthcare from a specialist health service under certain conditions laid down by the law, but restricted by society's need to limit costs and to prioritize the use of healthcare resources. The principle of equality forms the very core of the Norwegian healthcare policy and is enshrined in the object clauses of the Norwegian Patients and User Rights Act. However, all object clauses of the law, such as necessary, equality, equal access, good quality, promote trust, social security, respect, integrity, and human dignity, they're all concepts on which more than one opinion is possible. Just that it is possible to have more than one opinion about the concepts used in the UN guidelines on involvement of children in decision-making. The Norwegian Act accords the patient a right to necessary healthcare, but it doesn't define what counts as necessary healthcare. This clearly depends on professional judgment concerning the needs of each individual patient. Though knowledge and empirical analysis related to the regulation of healthcare distribution and prioritization still are scarce, we do now have some empirical studies. In a study from 2014, myself and Lene Brandt studied the impact of these individual rights have on distribution of healthcare in the field of orthopedics and cardiology. The study showed that the formalization of right to healthcare services had not led to homogeneous action among the medical professionals who are supposed to implement the law. Prioritization guidelines were used differently. While some professionals reported that the legal regulation affected their referral practice, others did not, indicated that significant variation in how individuals' rights were interpreted and implemented. Hence, legal regulation of individual rights to necessary health care appeared to have limited effects on the exercise discretion. Later studies indicate that priority guidelines have reduced this variation to some extent, but still there are large regional differences and difference within and between specialities. In a survey among medical doctors in Norwegian hospitals, Bjorvatn and Nielsen found that 72% of the doctors had knowledge about the priority guidelines, but only 45% consulted the guidelines when they were unsure in patient treatments. And in another work conducted by Henriette Aasen, Mette Hartlev, and myself, we compared the legal regulation to access to hospital care in Norway and Denmark, two countries with universal healthcare systems based on solidarity. In both countries, equal access to healthcare is a political goal, and citizens have an individual right to hospital care. In Norway, the right to hospital care is regulated by the Patient and User Rights Act, Section 21b, stating that the patient is entitled to receive necessary health care from the specialist health service. The right only applies if the patient can be expected to benefit from the health care and the costs are reasonable in relation to the effect of the measure. If granted a right, the doctors have to prioritize between patients by setting time limits for when health care should be initiated. Also, detailed and binding prioritization regulations supplement the Act. In Denmark, the right to hospital care is regulated by Healthcare Action 7. Section 7. Persons residing in the country have a right to the health care regulated by the Act. The Act does not outline the content and limitation of individual rights, which therefore will depend on political and professional decisions. In the Danish regulation, maximum waiting time is either 1 or 2 months, depending on the severity of the patient's condition. In addition, there are some relatively new rules for waiting time for investigation in hospitals. It's now stated in the Health Act that the regions shall ensure the patient that patient is investigated within a month, if possible. Without going more into details, this do illustrate some significant differences between the Norwegian and the Danish regulation. Norway can be characterized by a higher level of juridification and a more individualistic regulative approach. The Danish regulation, on the other hand, is more general and standardized. However, the regulation in both countries depend on medical discretion for its implementation. We conducted a vignette survey among cardiologists in the two countries. In our case, the vignette presented were formulated as two references with related questions. The study aims to studying similarities and variations in the assessment that doctors make when handling references to the specialist health service in both countries. As this is an ongoing study, the results are preliminary. But if the tendencies that we now can see are maintained, there are some interesting variations between Norway and Denmark, especially in regard to what time limit the doctor set for treatment or investigation. If you remember, the regulations in Norway and Denmark differ in this respect. Norway having more detailed, individualistic regulations, while Denmark have more general standards. I would like to present two preliminary observations. The first is that there is extensive variation in general. Some doctors give 1 week, others give up to 6 months. And remember, they are provided with the exactly same information about the patient's condition. The other observation is that the Danish doctors in general set shorter time limits than the Norwegian doctors for treatment or investigation. For the first vignette, the Danish doctor set an average of 4.6 weeks, while the average for the Norwegian doctors were 10.5 weeks. This gives us a reason to reflect on the fact that the legal standardizations in Denmark seem to provide shorter time limits than the legal regulation in Norway, which is more detailed and formulates stronger and more specified individual rights. So to conclude, the observations we've done in these studies tells us that regulating professional discretion is not an easy task. It's difficult to standardize professional practice. This indicates that introducing legal rights in such a way that they are effective often will require assistance from other policy instruments. It might be that creating a community in how the rights are understood by the regulators and the regulated may be of particular importance. As we have seen, there are differences in the Norwegian and Danish way to regulate access to hospital care. Norway with an individualistic approach to specified individual rights, Denmark with a more general and standardized legal regulation. The findings from the Vignette survey indicates that the more simple Danish model seems to give greater commitment to rule following. This gives reasons to reflect on how ambitious legal regulation should be in trying to constrain professional judgments. This study indicates that a more simple legal regulation may work better than very detailed and specified requirements. There is an inclination to think that the job is done when the right is formulated, but actually it's then the job begins. What we really need is to get more knowledge about is the condition for such right to have effect. I would assume that this also is of relevance when it comes to children's rights to participation in decisions concerning their lives and their welfare. Thank you.
Thank you, Anne-Mette. Thank you. Carl Harald, if you could present on the recent development with Norway and children's rights in the legal perspective. Thank you.
Thank you. Better now? Yeah. Thank you, and thank you very much for this opportunity. First of all, thank you to Anne-Mette for her reflections. And I just want to stress that regulating professional discretion is indeed difficult. Maybe it is impossible, or you could at least question to which extent. I will start with one strange example that was in the Norwegian newspapers a couple of days ago. It was, of course, it is happening in the capital of Norway, where everything went wrong. It was a child protection case, which was at first decided by the county board, and in Norway they can be brought before the city court and then appealed to the high court. And the High Court in Oslo, they by mistake received two appeals. It was the same appeal, but it was appealed twice in the system of the court, and therefore the appeals committee was composed by different judges, so two panels of judges were deciding exactly the same case. And this gives us some kind of test of discretion. And this was a child protection case that they should not decide the case on the merits. This was only on the procedure, but it was an important question whether this case should be presented before the full court or not. Because according to the appeal system in child protection cases, there is a screening panel, and the screening panel should then say yes or no to have a full hearing of the case. And the two panels came to the opposite conclusions. Of course, this is one single case, and I'm a lawyer, but I have realized that much, that you cannot from one single case make any conclusions. Of course, this could be sound discretion. Like in all other cases, there are majority and minority within the court, and this could be just an example of this. Or it could be an illustration that there is too much discretion within these cases, and it's very difficult to kind of, we have to make more detailed regulations in order to kind of facilitate this decision-making process. But as Anne-Mette mentioned, it is, you can fill it with rules, but it's not certain that that will give the outcome that you want. There's a case which can make, it can be thought-provoking in a way. Then to move on to the UN Convention on Rights of the Child. And as all member states, there are concluding observations also to Norway, and the latest are from May this year. And within the time limit, I cannot go into all the details, but I will highlight some of them that could be of interest when it comes to the right to participation. Four of the main topics of the CRC committee when it comes to Norway is local differences. When you go into services to children in Norway, there are major differences between the municipalities. Secondly, it's juvenile justice. I think, but there has really been an improvement when it comes to juvenile justice in Norway. If you see the number of children in prison, that has decreased in recent years. Then it is about child protection and refugee children, and I will shortly look into the two latter. So it is about child protection and refugee children. When it comes to refugee children, there has been many cases before the Norwegian Supreme Court, and many of the decisions has been decided with dissenting opinions, and there is indeed a kind of division and tension within the Norwegian Supreme Court. And it's fascinating because some of the cases are concerning the right to be heard, but most of the cases are concerning the essential question: should they stay in Norway or should they leave the country? And it is often, these are decisions to leave their country of origin are normally not taken by the child, but it is taken by the parents. The child has been living in Norway for a number of years, and then the question is, how strict should you be? And you can see that there are different viewpoints, and it's partly about discretion, because this is also about enforcing the immigration policy. And you see that according to the recommendations by the CRC committee, they indicate that Norway should be a bit more lenient on these cases than the practice of the majority of the Supreme Court has been. Then it is about child protection, and if we are speaking about discretion, if you look at figures in Norway throughout the country, there is a significant difference between the northern part, especially the northern county of Finnmark. For those living in Norway, you know that there is a kind of intense public debate on the status of this county. Should it be still a single county, or should it be joined by their neighbors? But that's another issue. It's very fascinating to see that in the northern county of Finnmark, it is 3 or 4 times higher use of interference, removal of children, than it is in the central part of Norway. And of course, this could be discretion in a way that is sound discretion, because in northern Norway, the social conditions are worse, and that is the trigger factor of the differences. Or there could be variances when it comes to use of this measure that could not be explained by this. So that is an interesting topic of research, and it's also addressed by the CRC committee. They're concerned about this. As a last from the which it's a couple of years old, but still I think it's a custody dispute between 2 parents. Yeah, I hope it works now. Between 2 parents, and of course affecting the child. And the question was, should the child be heard? At that time, the age limit of hearing of children in these kind of cases was 12 years. The child was 11 years, and it was not heard. And the court said that they wouldn't involve the child due to the fact that it will be so stressful for the child to be involved. This was a long-lasting conflict, which was even brought as soon as the custody case was settled or was final. Well, then the parent initiated another case, not involving where the child should live, but when it came to access. And the High Court decided not to hear the child because it was in the best interest of the child not to be involved in the case once more. And it was a lot of discussion about this case in Norway, and many claim that you couldn't use the right there was no conflict between the right to be heard and the right and the best interest of the child. And I think I agree on that. On the other hand, I think we should also stress that to be involved in these kind of cases is indeed stressful for children. And when it comes to, if we move not from custody disputes, but child protection, then we consistently held that children should be involved. And I agree, it is important to involve the child. But on the other hand, I think it's also important to emphasize before the child that the decision on where the child should stay, that is not a decision for the child. That is a decision for the adults. It is a difficult decision, of course, and it's also difficult for the adults to, on the one hand, we shall involve the child. On the other hand, very often a child living with one of the parents will claim that I would continue to stay here. And I think that this is difficult. And I think we often, when you see documents from various human rights bodies, I think that they do not fully explicitly address this issue, because you cannot say that we should listen to you, and also, for example, when it comes to child protection cases, we cannot pay too much attention to the viewpoints of the child, because there is a risk that the child is affected by the conflict and has some kind of loyalty to the parents or to the foster parents, depending on where they are living. So I think this is one of the most difficult questions when it comes to discretion. You should listen to the child, but how much account should you pay to the viewpoints of the child? This was some reflections. I could have continued, but I think that my time is up. Yeah. So thank you very much. Thank you.
Thank you, Karl. And now Aske, if you will. Thanks.
You can hear me. I do it the other way around. Thanks for having me. Thank you, everyone. Yes. My introduction is actually the same as you heard 3 times already, but I'm going to go with my script. Sorry. Now, the Convention on the Rights of the Child, the CRC, is a catalogue of rights specifically aimed at protecting the integrity of each individual child. The Convention's potential lies within its global reach and its cosmopolitan human rights ethos. If done properly, a correct implementation and enforcement of the CRC would infuse the rights of every child in all areas of public life throughout childhood. I will now focus on professional decision-making on street level in child protection services, and I will try to put forth certain ideas that the field of practice can carry in order to abide by human rights. If you want a more elaborate version, you can wait till September, because there's a book about it coming around the corner. I had to plug it, sorry. But welcome to the land of political theory. When children become subjected to detrimental care, protection according to the CRC must not only abide by the formal semantic intent of specific rights provisions, but also positively enforce the CRC in accordance with the fundamental normative principle of human rights that underpin the Convention itself. Such a fundamental human rights principle comes conceptually prior to the specific rights provisions of any human rights convention and can be referred to as a basic human rights standard. If we focus upon the CRC and child protection, we can argue in broad terms that such a standard constitutes a fundamental defense of the individual child's liberty and integrity against detrimental care by protecting the interests of the child. It is important to stress that the principle of the best interests of the child is speaking directly to a principle of liberty, namely what protection the child would want if it could rationally choose as an adult what to do. In order to accommodate the CRC throughout child protection services, the CRC regulations and its human rights standard must actively become a point of reference and govern in all matters, as it were, as it says in Article 3 in the CRC. Accordingly, interpretation and active enforcement and implementation of the CRC through decision-making and through policy development must be constitutive of professional practice as a legitimating factor for decisions. Hence, rights become a major part of what warrants actions in practice. So what does this mean? What becomes challenging to the application of knowledge and thus to the epistemology of rights-based professional child protection is not only that every action, every decision must have the child's best interest as a primary consideration, which is what the CRC demands, but also that a professional must know that such an aim is morally and factually indeterminate. What is implied by indeterminacy is that a decision in the child's best interest is always a value judgment, in that it is a matter of locating one triumphant rational best interest of any child above all other interests of that particular child. The two problems with indeterminacy are called the prediction problem and the evaluation problem. I have this from Robert Nukin. Wait. I got lost now. Sorry. Cliffhanger?
What's coming?
I should have found it right now, but I don't. Yeah. So, I should explain what the prediction problem is. Okay. The prediction problem alludes to the problem of making decisions without knowing what can be the spectrum of interests that a child has or will pursue in the near and distant future, especially distant future. That's where the indeterminacy becomes more and more apparent when you decide something here and now that this child, it will affect the child in years to come. The evaluation problem is about the uncertainty of the normative key to unlock what is the best interest from the second one. Indeterminacy is important because the principle of the child's best interest speaks, as I said, directly to the principle of liberty, and where adults can act upon self-interest, children cannot. Hence, discussing indeterminacy and its role in developing rights-based practice is important, and it becomes a touchstone for whether or not the human rights standard has been dealt with or not throughout, for instance, educations. Due to indeterminacy, the best interests of any child can only be assumed. Professional practices become a matter of simulating the child's own rational choice as if that child was an adult that could act upon its interest. The picture we had here with the prose earlier was, I want you to get into my heart. It's actually kind of illustrative for where I'm going with this, because you need to locate that. Although no one knows exactly what is in a child's best interest, qualified claims can either be raised or in some cases become methodologically embedded in practice. As such, a final decision can only reach rational acceptability through a procedure where different claims are raised and that culminate in a final and ultimate claim acceptable to all as a rational thing to do. For those who know their Habermas, I'm kind of influenced by that. The process can be referred to as approximation, and a rule of approximation stipulates that all relevant claims assist in qualifying what is in the best interests of the child, but without making a claim upon a decision de facto being in a child's best interest, which is indeterminate. Once mutual understanding is reached after a reflexive process of competing claims, a decision can be made that is qualified. Only by infusing professional practice with some version of the approximation rule, so that decisions can be rationally justifiable, can a claim to correctness regarding what is in a child's best interest be raised. In a modern state logic of delegating authority down to professionals in child protection, the politicians also set restrictions and define the formal jurisdiction for the professions. But they cannot define the autonomy. I'm talking about the area they don't. In this way, the knowledge base of child protection professions enter into a symbiotic relationship with democratic rule of law. Professionals are not only governed through regular law, having all these restrictions, whereas practices must be according to law and policies, but they are also governed through settled and agreed upon constitutional principle norms. That's what democracy is all about, that underpin the regular law itself. They are delegated an authority to act in a certain way and not the other. This is also where the human rights standard enters as a fundamental and constitutional guiding norm for professional practice. I don't mean constitutional in a strict legal sense, sorry. If the professionals do not act in accordance with their delegated authority, which constitute the formal restrictions, and this discrepancy becomes too large between practice and the democratic and constitutional ethos of the delegated authority can be revoked. Hence, the human rights standard and the CRC set a distinct and real direction for what type of practice can be labeled as professional when applied to child protection. So once again, this is why indeterminacy becomes a touchstone for professional practice. In the attempt to approximate a decision that is in a child's best interest, we have now touched upon four main challenges that professional practice must cope with. So the first one is nobody holds the right answer to the practical problem what to do with the child and his or her care. So for instance, this opens up that each decision needs to not predefine how you do things. For instance, talking to the child should be an obvious way to go. Second, every argument that is relevant must be included. Third, a decision-making procedure must be able to extrapolate the relevant aspects of each argument in order to establish an ultimate claim to correctness. You have to know that you have to be sure that what you're doing is correct. That is how you can be held accountable. So fourth, it must do so because it is in line with the delegated authority. So, thank you.
Thank you. Helen, we've asked you to comment on these three. Lots of for you to comment on, so good luck.
Thank you very much. So a broad range of issues dealt with there, and I'll try and summarise them under what I think to be 5 key points to try and give lots of opportunities for you in the audience to participate in the discussion. I personally have so much to say about each of them, but I'm going to try and synthesise it into a few points. I think the first big question that was immediately posed by Anna Mette was that standards, values and principles are important for guiding practitioners. And so that immediately raised the question for me as to whether we are happy with Article 12 itself as a blueprint for participation. There's a lot of presumption that the CRC and Article 12 itself is a good blueprint, but we've already heard today that there are some real limitations of that. The Change Factory has really told us that age and maturity are really unsatisfactory variables by which we should determine participation of children, and that emphasis on age and maturity in Article 12 leaves an enormous amount of discretion to adults as to the conditions under which our participatory rights can be exercised. So that's the first kind of point of discussion. The second big point then is is this another quote from Anna's paper was that the job isn't done when the right is formulated. That's really just the start point, and it's often a very inadequate starting point. Are we really sensitive to the resources that are needed to give effect to good quality participation and meaningful participation? And we often have these participation discussions. I know that I've had participation discussions for the last 20-odd years in a complete resource vacuum. And that's becoming even more of an issue now than it, I think, ever has been. Do we have really the resources that are required for the continuity of support in the services that are working on the front line with children? I know in the UK, children in the child protection system are working through 7, 8, 9 social workers in any one year. And how can we really develop a relationship of love and obligations of love when children are shifted between so many different professionals? The other thing is, are we sufficiently sensitive to the local context? And I think this was a feature of Carl's paper as well, that resources differ dramatically from one region to another. Local authorities have enormous discretion, certainly in the UK, to allocate those resources. So should we be looking more at the local level and less at the centralised level? And the third issue then is whether we should be working more with economists, health economics, and certainly Anna's paper, there's an abundance of work in health economics and early childhood education that tells us that actually there's a strong case for investing in children as opposed to investing in many other groups, that we can make a special case for extra economic investment in children, because we know that the research tells us that if we invest in childhood, then it has significant gains as children enter into adulthood, which is better for society generally. So do we need to really think about how we work with economists as children's rights experts and advocates? Should we be working on the methodologies, drawing on health economics and other economic approaches, so that rights are the starting point and not the chance outcome of these initiatives? Then the third big, I think, question for me that came out of the papers is whether there is too much emphasis on the legal participatory process and not enough on the substance of our legal rights. And I think child-friendly justice has reinforced this emphasis on procedure without really looking at the substance of the rights that we're seeking to involve children in. I was very struck by what Gloria was saying about anger and how she had to calibrate her kind of emotions to engage with the decision makers. But I actually think you have an absolute right to express your anger. We've had a more contraction in our children's services than in any other areas of services as a result of the global economic crisis. There's lots of evidence around that produced by the UN. Children and childhood is a political movement, and we have every right to enable them to express their anger to our decision makers. And I guess it's how we should support that. Whether we should be asking the decision makers to reposition themselves, move into children's forums rather than requiring our children to calibrate their emotions and move into adult spaces. I think a good example of why the sort of problem with emphasising process as opposed to outcomes or substance is that, for example, we can enhance young people's participation in the criminal justice process without properly really continuing with our campaign to remove detention of children, to really address the low ages of criminal responsibility. There's no point in engaging children in participation around prisons if we actually think that prisons for children are wrong. And so is the focus of our efforts balanced correctly? The fourth point then, I think, is, are we focusing on the most relevant levels of decision making? And Carl's talk about discretion really sort of resonated with me, that the courts are the end point of a series of decision-making fora. The judges are the most visible, perhaps, of a series of decision-makers, all with enormous discretion. But should we be looking at children's participation in the private family sphere? Should we look at children's participation in decisions around education and school governing bodies and teachers? Should we be looking at local authority budgets and how managers allocate those resources and how children participate in the allocation of those resources? Should we be looking at the prosecution authorities and how they engage with children in their sort of strategic planning? I think added to that then is the fact that we have huge, and Anna's paper reinforced this, that we have a huge number of non-state actors now operating in our children's rights field. And yet the UN Convention on the Rights of the Child targets states. It doesn't target private bodies. To what extent are these private entities, increasingly commercial entities, held to account for the state's obligations under the UNCRC? And in this increasingly neoliberal environment, we have to grapple with that issue. And fifthly, and finally, I think I might have covered everything. But fifthly and finally is there too much emphasis on participation as a process and not enough emphasis on I think I've said some of this, but I think what I wanted to talk about was Carl's points about the risks associated with the participatory nature of participation, but particularly the emphasis on giving due weight to what children actually say, so the outcomes for children. The risks of going by what children really want or express as their outcomes. I think there's quite a lot of research on that. And certainly Asghar's paper was very thought-provoking in its kind of theoretical framing of some of these issues. The fact is that, yes, decision-making is a risky process. We can't really get away with that. But adults making the decisions on behalf of children is no less risky than children making decisions on their own behalf. Certainly, you could say that adults might have the wisdom and experience and resources to make better decisions on behalf of children, but the research actually doesn't necessarily support that. What we know from Asghar's paper is that to determine what is best for children demands a degree of transparency, and it certainly demands talking to children. But that participation has to have a meaning. It has to have a point to it for children. A lot of it must surely be about how the child responds to a decision. How do we create the conditions under which a child can actually trust the decision that is actually made so that they are committed to complying with it and to living with the consequences of it? And the only way that we can really develop children's trust in the decision is if they're engaged in making it. Aoife Daly, a colleague of mine from the University of Liverpool, has recently published a book around children autonomy in the courts, and she's suggesting a complete reformulation of participation and decision-making. She says in her book, and it's absolutely worth a read because it's a global comparison of participatory practices in the courts, she said that actually we should forget about best interests altogether. She says that what we should really do is go by what the child says in all best interest decision making, unless there's a risk of significant harm to the child. So going by what the child says should be our default position, and that there should be a sort of justification for deviating from that rather than the other way around. So there's just some Aoife Daly, so it's Children Autonomy in the Courts, and it's published by Brill. Okay, so there's some thoughts for discussion.
Thank you. Okay, so we have 10 minutes left, so I wanted to open for questions from the audience, if there are any. No? Yes, welcome.
constitutional theory around best interests of the child. So you stated that the best interest of the child is about autonomy for the child, and sort of a rules-in way we try and find out what the child would have decided if they had the capacity to decide at that time. And I wonder if the best interest of the child, though, can be just understood in a sort of liberty freedom framework. Isn't it also a substantive value that we actually instrumentally value rights for children at an early stage in life because of the potential long-term consequence.